Welcome to Laws 13013, Legal Professional Conduct, Topic 7, Communication and Control. I'm Stephen Colbran. This week we will focus on two issues. First, the balance of control in the lawyer-client relationship, and secondly, communication. As one US legal critic put it, many of us head for the bartender who mixes the stiffest drinks. So when we hear of techniques used by certain defence barristers to get their client off, we're appalled. But if your child was arrested or charged, for example, that's probably the lawyer we'd want to hire. In other words, we get the lawyers we want or deserve, depending on how hard we want to play the justice game. The reading for this topic is Isaiah Ross, Ethics in Law, Lawyers' Responsibility and Accountability in Australia, 5th edition, Chapter 9. After studying this module, you should be able to outline three models of control concerning the lawyer-client relationship and discuss the advantages and disadvantages of each. You should be able to identify three legitimate expectations that clients of legal practitioners normally possess. You should be able to define and appraise the parameters of legal practitioners' obligations to both inform and advise, and also to obey their clients. You should be able to identify the particular problems that lawyers representing disadvantaged clients might face, and also consider problems that may arise from counsel's inexperience. Let's look at three control models: the lawyer control model, the client control model, and the cooperative control model. Firstly, the lawyer control model. Lawyers' training, detachment, and objectivity enable them to handle problems better than emotionally involved clients. Weak clients trust and become dependent on lawyers. The lawyer control model is preferred by the profession, particularly if clients are poor and uneducated. It is the dominant approach in family, criminal, and tort work. The client control model. Under the client control model, clients make important decisions based on technical information supplied by their lawyers. Lawyers follow client instructions unless they're illegal or unethical. This approach is apparent where clients are powerful, whether by position, wealth, or education. Legal problems may need to be framed in a broader context, and the client control model is dominant in the corporate law area or the corporate world. The cooperative control model. The cooperative model is also known as the care model. The lawyer and client learn as much as they can about each other's attitudes and goals and seek to come to a common solution to the problem. There is open discussion on an equal footing, and moral dialogue are features of the cooperative model. So, perhaps on one view, the appropriate model depends on the nature of the client, their education, primarily, I suspect, would be their education. Okay, now let's look at information and advice. The main complaints made against lawyers include a failure to communicate, a failure to follow instructions, and a lack of courtesy. The law is a service business, hopefully providing quality service to its clients. Client care is an essential feature of the lawyer-client relationship. There are some guidelines and some legislative provisions which assist in the process of promoting information advice. They are the Queensland Law Society Guide to Client Care, Communication and Service, the link to which is found in the notes. And also in relation to costs, you should have a look at the Legal Profession Act 2007 Queensland, Part 3.4, Cost, Disclosure and Assessment. The Legal Profession Act 2007 Queensland Section 312 requires disclosure of cost estimates before a negotiated settlement of a litigious matter is executed. In Queensland, there is no obligation for solicitors to inform clients of the availability of legal aid. There is also or there is an obligation, however, to inform clients if a solicitor intends not to apply the full rigour of the law to an opposing party. So take the time and have a look in particular at the Queensland Law Society Guide and the cost rules. The duty to obey. Lawyers are agents of their client principals and owe a contractual obligation to follow client instructions subject to three things: the general law, their obligations as officers of the court, and refusing unethical or illegal requests. A lawyer should investigate client instructions that make no sense or are inconsistent with known facts derived, for example, from documents or from discussions with witnesses or other parties. So you need to be vigilant and don't assume necessarily that your client is telling the truth. You need to be careful and look what the facts suggest. Let's now look at the general conduct of a case. Firstly, we're going to look at three bar rules, 39, 40 and 41. Bar Rule 39 provides that a barrister must seek to assist the client to understand the issues in a case and the client's possible rights and obligations, sufficiently to permit the client to give proper instructions, including instructions in connection with any compromise or settlement of the particular case. Bar Rule 40 states that the barrister must, unless the circumstances warrant otherwise in the barrister's considered opinion, advise a client who is charged with a criminal offence about any law, procedure or practice which in substance holds out the prospect of some advantage, including reduction of a penalty, if the client pleads guilty or authorises other steps towards reducing the issues, time, cost or distress involved in the proceedings. The third rule is Rule 41. This falls under the heading of independence and requires that a barrister must not act as the mere mouthpiece of the client or of the instructing solicitor, and must exercise a forensic judgment called for during the case independently after the appropriate consideration of the client's and instructing solicitor's wishes where practicable. So it's important that you just don't follow blindly what people are telling you, that you actually think about it and make appropriate decisions. The case of the Queen against Burks, 1990, 19 New South Wales Law Reports 677, discusses the implications of an inexperienced counsel's failure to adequately represent their client. In this case, Chief Justice Gleeson said, "A court of criminal appeal has a power and a duty to intervene in the case of a miscarriage of justice. But what amounts to a miscarriage of justice is something that has to be considered in the light of the way in which the system of criminal justice operates. As a general rule, an accused person is bound by the way the trial is conducted by counsel, regardless of whether that was in accordance with the wishes of the client, and it is not a ground for setting aside a conviction that decisions made by counsel were made without or contrary to instructions, or involve errors of judgment or even negligence. However, there may arise cases where something has occurred in the running of the trial, perhaps as a result of flagrant incompetence of counsel, or perhaps from some other cause, which will be recognised as involving or causing a miscarriage of justice. It is possible and undesirable to attempt to define such cases with precision. When they arise, they will attract appellate intervention." Let's now move on and consider the whole issue of guilty pleas. In the case of Maxwell against the Queen, 1996, 135 ALR 1, at page 7, Justices Dawson and McHugh stated, "An accused is entitled to plead guilty to an offence with which he is charged, and if he does so, the plea will constitute an admission of all essential elements of the offence. Of course, if the trial judge forms the view that the evidence does not support the charge, or that for any other reason the charge is not supportable, he should advise the accused to withdraw his plea and plead not guilty. But he cannot compel an accused to do so, and if the accused refuses, the plea must be considered final, subject only to the discretion of the judge to grant leave to change the plea to one of not guilty at any time before the matter is disposed of by sentence or otherwise. There are some advantages in pleading guilty. These include saving community time and money, avoiding the emotional stress for victims and witnesses, in view of that possibly receiving a lesser penalty, and also it can be considered as a mitigating factor. Barrister's Rule 79 provides that a barrister, briefed to appear in criminal proceedings whose client confesses to guilt to the barrister but nevertheless maintains a plea of not guilty, should, subject to the client accepting the constraints set out in the sub-rules that follow, but not otherwise, continue to act in the client's defence. So what are these constraints in the sub-rules? Firstly, the barrister must not falsely suggest that some other person committed the offence charged. They must not set up an affirmative case inconsistent with the confession that they received. They must ensure that the prosecution is put to proof of its case. They may argue, however, that the evidence as a whole does not prove that the client is guilty of the offence charged. They may argue that for some reason of law, the client is not guilty of the offence charged. They may also argue that for any other reason, the client should not be convicted of the offence charged, and finally must not continue to act if the client insists on giving evidence denying guilt or requires the making of a statement asserting the client's innocence. So if a client instructs you to plead not guilty on their behalf, but nevertheless confesses to you that they have in fact committed the offence, then you must look very clearly at Rule 79, because it places severe limitations on what you can do in the courtroom. Another class of clients we need to consider are clients with disabilities. Adversarial skills are often problematic for solving family law disputes, and there's a need to be careful to define the best client outcomes, particularly in such cases. They often involve children. Practitioners need to deal with the whole person, and children should be able to express their interests. The role and need for separate representation of children needs also to be considered. I've included in the notes a summary of two cases which I'd like you to take some time to consider. They are Colbran and GIO Finance Limited, which is a Court of Appeal case from New South Wales, and secondly, P&P and the Legal Aid Commission of New South Wales, Human Rights and Equal Opportunity Commission intervening, 1995, 19 Family Law Reports 1, which is a full family court decision. This concludes Topic 7, Communication and Control. Next week we'll be looking at Topic 8, Competence and Care.